Join us on the line. Sir, you're welcome to Eyewitness News.
Thanks for having me, Sander.
You're both a communicator for your party, but also a lawyer. Now, from the legal side of things, for those who may not have understood why we've been reporting from the High Court and suddenly we are saying is a court of appeal that has acquitted and discharged your colleague, summarize for us what your legal team decided to do while continuing with the trial at the High Court, for which reason you got a verdict you got today.
Well, Sander, thank you. The position of the law is that in criminal cases, when the state arraigns a person before a court of competent jurisdiction to try him or her for a crime, the state has a responsibility to adduce sufficient evidence to establish the ingredients or the particulars of that charge. So when you look at every charge sheet, there is a statement of offense and there is a particulars of offense. The particulars of offense is basically an explanation of what, in the view of the state or the prosecution, is the conduct of that accused person that constitutes a crime, for which reason they are prosecuting him or her. Now, if by the time the prosecution closes its case, meaning when they are done calling all their witnesses and adducing their evidence, the court or the accused is of the opinion that sufficient evidence has not been adduced to prove the particulars of the offense, that accused person can file an application for no case. Okay, for a submission of no case, which basically means that, look, court, the prosecution has completely wasted your time. There is no case for me to answer, because the very case they brought, they have not been able to adduce sufficient evidence to establish the particulars or the ingredients. Now, when that application is made, the court is bound to make a ruling before it orders the accused person to open his or her case. If the court makes a ruling that the prosecution has not made a sufficient case, then the court will say there is no need for you, the accused person, to even open your defense. So the matter is dismissed, accused person acquitted and discharged. If the court forms the opinion that a sufficient case, prima facie case, has been made, it will order the accused person to open his or her defense. So that is by way of legal education. In the present case of Dr. Ato Forson, at the end of the prosecution's case, lawyers for Dr. Ato Forson filed an application for submission of no case. And the trial court dismissed it and ordered Dr. Ato Forson to open his defense, because the court was of the opinion that the state had adduced sufficient evidence to establish a prima facie case. There was a case to answer. Honorable Mr. Richard Japa also filed an appeal to challenge this. So it is that matter which the Court of Appeal has determined today. You know, when you file an appeal, it doesn't operate as a stay of execution. It doesn't freeze the substantive trial. So the trial has been going on, but that appeal has been pending in the Court of Appeal, which is a higher court than the High Court. And today, lo and behold, the Court of Appeal gave its judgment on the matter. And what some of us have been saying all along, that this case was frivolous, it was baseless, it was nothing but political witch hunt, it was nothing but persecution of the leader of the NDC caucus in Parliament, who has been at the forefront of our struggle against the misrule, the misgovernance, the bad policies of the Kufuor-Bawumia NPP government. And that same was calculated to cower him. We have been vindicated. The Court of Appeal, by a majority decision of 2-1, has held that Dame's case was frivolous. Ato Forson has no case to answer. It was totally wrong for the trial judge to have ordered Ato Forson to open his defense. And so Ato Forson's application for submission of no case has been upheld, and he has been acquitted and discharged, which automatically terminates the matter in the High Court. Unless and until a higher court, in this case the Supreme Court, sets aside the decision of the Court of Appeal. So in summary, this is what has happened, and we are excited because this is victory for the rule of law. The Court of Appeal has demonstrated that indeed they are still, persons of conscience, people who are alive to their fidelity to the Constitution of Ghana, people who uphold the principles of justice and accountability. What this case shows that we still have such people on the bench. And so all hope is not lost. We are very refreshed and encouraged by this decision. Godfrey Dame has been badly exposed for who he really is, a local fixed match merchant. His frivolous and ludicrous case has been exposed as such, and we are excited about it. We thank God, and we thank all Ghanaians who spoke out against this clear case of witch hunt and persecution. People like Bryce Simmons, Franklin Kujo, Martin Pebu, and all of them, all the lawyers, all the ordinary citizens, the civil society organizations, who in good conscience saw everything wrong with what was going on and spoke against it, took a stand against it. We salute them for their solidarity. This is certainly the way to go. When we come together, there is no way that evil can prevail over the truth. And that is what we have demonstrated in this matter.
Okay. What you describe as justice, victory for the rule of law at all, the Attorney General considers grossly unfair, and he says is inimical to the fight against impunity and abuse of public office. Essentially, it emboldens persons who break the law, he says in that statement. What's your response?
Well, what is unfair and inimical to the nation is for an Attorney General who is supposed to be the leader of the bar and a champion of the rule of law and the ethics of the profession to engage in clear professional misconduct and even criminal conduct just to secure the conviction of a political opponent who he knows to be innocent. You see, that is what is inimical to the national interest. When an Attorney General goes out of his way to engage an accused person who is represented by a lawyer, when he knows that the legal profession prohibits him from doing that, and he engages that accused person for the sole purpose of misleading him, goading him, suborning him to implicate an innocent man. There is absolutely nothing wrong with the Court of Appeal decision. I've taken time to study it. And if anybody says that there is something wrong with the decision the Court of Appeal has taken, I dare them to cite it. They should pick the ruling. You see, to further prove the malice of Godfrey Dame in this whole matter is the fact that he did not even have the decency and the patience to wait for the ruling of the Court of Appeal before issuing that useless press release. He didn't wait for it. So at the time he was describing the decision as inimical to the national interest, he didn't even have the benefit of the reasoning that went into the Court of Appeal decision. So there's a man who clearly is a sore loser. There's a man who is hell-bent. He is not interested in achieving the ends of justice. He is only interested in oppressing, intimidating, harassing, victimizing political opponents for cheap political goal scoring. And that is why God has exposed him.
Very well.
Today, nobody respects Godfrey Dame. He's the worst Attorney General in the history of this country. The first Attorney General to have been cautioned or advised by a trial court to stay away from a matter that he is prosecuted. That is how disgraceful Godfrey Dame has been reduced to. And so the castigations is peddling against the Court of Appeal, very unfortunate, but without no basis. Show me. You see, that if you look at the decision, the reasoning of the Court of Appeal is very simple. And let me summarize it for you in 1 minute. The Court of Appeal says, you say Ato Forson has caused financial loss to the state. What did Ato Forson do to cause financial loss to the state? You say all he did was that he wrote a letter to the Bank of Ghana and the Controller and Accountant General for letters of credit to be established for the procurement of the ambulances in question. Then the court said, okay, what is a letter of credit? Your own witnesses, including Ajima Menu, the then Minister of Health, agreed in the witness box that a letter of credit is not payment, but only a guarantee of a promise of payment. And so if a letter of credit is not payment, and all Ato Forson did was to write a letter to the Bank of Ghana for a letter of credit, which is not payment, to be established, then the court says Ato Forson has not caused financial loss to the state. If there is any loss at all, then it should be the officials at the Ministry of Health who had a responsibility to ensure that the conditions in that letters of credit were fulfilled before authorizing payment. Then you should be prosecuting them, not an innocent man. Ato Forson.
Thank you so much. Thank you so much. Thank you so much for speaking to us. That's Sammy Gyamfi, National Communications Officer of the NDC. Let me go on the other line and speak to the attorney.